Welcome to Shenkman Education. My name is Marty Shenkman, and the topic for this video clip is the definition of descendants. It's vital to the LGBT community, but it's also important to a lot of other couples who use artificial reproductive technology, the acronym ARC, A-R-C, artificial reproductive technology, ART, to bear children. Really important because if you have a child, you want that child to be an heir to your estate. What if they don't meet the definition of descendant? So let me give you an example of how this not only has come up, but how it's going to come up with great frequency, and it's a big issue that needs to be addressed proactively. And I'll give you some ideas how to do it. You really need to speak to an attorney about this. This is certainly not a DIY, do-it-yourself project. So let's say Grandpa set up a trust for all his heirs, all his descendants. Grandpa's will, especially, or trust that set up the will, or will that set up the trust, or trust that he created outside of a will, done years, decades and decades ago, probably didn't even contemplate assisted reproductive technology or LGBTQ families because the world was different then. So what they may have is even language like a child is only a child if born within wedlock, or a marriage is only deemed to exist if it's between a man and a woman. There can be very restrictive provisions. In many cases, the provisions defining who a descendant is or what a marriage is to help determine whether somebody should be an heir or not are not based on exclusionary language, like I just illustrated, but just really vague language that doesn't really necessarily address the issues that may arise. So fast forward, great-grandpa's trust is still there, and you're a beneficiary, and you would like your child to be a beneficiary, but the definitions don't work. Is there something you can do about it? Maybe. One of the concepts, and you have to be very careful, the law is not clear, you may be able to have the trustee decant the trust. Decant is when you take an existing trust, you create a new trust with new definitions, and you pour the old trust into the new trust. And if you change the definitions, and you have to get an opinion from an attorney in the state that the trust is governed by, and you may want to move to a state that has different laws before you even do this, if you can pour an old trust into a new trust and modify the definitions of descendant, that may solve the problem. The issue with that, no pun intended on issue, but the problem potentially with that is changing a definition a mere administrative matter, or is changing a definition adding a new beneficiary? And if it's viewed as the latter, it may not be permissible under many state laws. It's viewed at the former, meaning not an additional beneficiary, but a change of administrative provisions, maybe it's viable. Here's another possible approach. It may be feasible to exercise a limited power of appointment in the trust to appoint it to a new trust that benefits your child, your heir, your descendant. What is that and how does that work? Many trusts create what are called powers of appointment, giving a certain person the right to appoint trust assets. Some are very broad, some are very narrow. You have to look at it and understand it and see what it permits. But for example, you may be the beneficiary, continuing the same hypothetical, of your great-grandpa's trust. He may have given you the right under your will to designate where those assets go. And if that right exists, all you have to do is exercise that right under your will and appoint it to a trust for your children. Covered, done. So those are several different ways that you may be able to address this issue of defining descendants if you or a loved one, someone you treat as your child, that may not qualify within the definition in the document, to get them included. Here's a final approach. And again, these are complicated and you really need to get proper legal counsel to address it. Let's say there is no limited power and decanting that we talked about as an initial example won't work. What you might be able to do, and if the state law where the trust is won't permit it, move it to a state that may, and make sure you get an attorney in that new state where you moved it before you move it to confirm you can do this. You may be able to have the trustee decant the trust into a new trust that doesn't change the definition of descendants, because that may be an issue of creating a new beneficiary, which may not be permitted, but adds a limited power of appointment to the trust in your favor. Then, maybe you wait a year, but then you exercise that limited power and appoint the assets to a new trust that include the intended descendants. To summarize, lots of old trusts exist, tons of them with lots of money in them. Lots of trusts are being done now without the thought of an LGBTQ heir. And what you need to do is address the definition of descendants so you can make sure your loved ones are included. And I've given you a number of different approaches that may be viable. You need to get a specialist in the state where the trust is and in the state where you may move the trust and sort it all out. Much better to address this proactively even before there are children or descendants or anyone you want to benefit, because when it's a hypothetical, it's less likely to create as much of a problem. So thank you for joining me. Please remember that all the information on this video clip is for informational purposes only, educational purposes. Do not take any legal action without appropriate professional guidance. For more information, see shenkmaneducation.com. Thank you.